Good morning, everybody. Today is the 29th of April 2025. We are resuming with the tribunal in the matter of Judge Parker. We apologize for the delay, which they have started at 10 o'clock, but we're not able to do that because a member of the panel, Judge Barokowitz, went to the wrong Capital Hotel instead of this one. So as a result, there's been some delay. We apologize for that.
I personally apologize to everybody for this delay.
Is everybody connected? Do we have counsel for the various parties? Dr. Nzim, are we all right?
I'm ready.
Yes, are we? Oh, yes, okay. I see Advocate Mikedi and Outlander there, but I don't see Mr. King. Is he connected?
I'm here.
Okay.
Together with Ben Prinsley.
All right, thank you very much. Dr. Nzim?
Chair, perhaps the right place for me to start is paragraph 46.6 of my head, where I make reference to subparagraph 1.6 of the Bangalore Principles. And with your permission, Chair, if I may just read subparagraph 1.6, a judge shall exhibit and promote high standards of judicial conduct in order to reinforce public confidence in the judiciary, which is fundamental to the maintenance of justice. In subparagraph 46.2 of my heads, I make mention of the fact that this tribunal is in a fact-finding mission or exercise. And with that in mind, the tribunal has to establish the truth in this matter. And with that in mind, and in my introduction on the first few pages of my heads, I restate the complaints, the two complaints, up to page 3. And then I make reference to the decision of the Judicial Conduct Committee, which resolved that both individually and cumulatively, the two complaints, if established, will prima facie indicate gross misconduct on the part of the respondent that will be seen as bringing the judiciary into disrepute. And on the next page, I deal with the terms of reference, which are part of the record, and then tackle the issue of the response from the respondent. I make the submission at paragraph 8 of my head so that silence from the respondent has first closed the door to this tribunal in knowing what actually happened or what his version is. That is not what is expected from or of a judge. Then on the next page, I deal with all the evidence which has been led in February, particularly the corroboration in relation to the first complaint of the 10 justices. And we've heard thoroughly all the justices confirming one aspect, that the assault took place. And that is the truth. And since it took place, the respondent's change of tact, indicating that it never took place, led to the stressful tension within the bench in Cape Town, to the extent that a number of justices resolved not to sit with the respondent or share the bench with him. And that is the consequence of the untruth. And the best approach, Chair, in this matter is what I suggest in 16.2. And there I state the following. And this is in relation to the mutually destructive version. The second version, which is set out in 16.2, is that Dr. Hlophe did not assault the respondent. And I submit that that version because it cannot stand the test of time. With that having been eliminated,
Sorry, I don't know if council are hearing you. I imagine they are. All right, you can
thank
proceed.
you. With that false version having been eliminated in relation to the first complaint, then there's only one that remains. That indeed the respondent was assaulted by Dr. Hlophe and suffered the injury, and his fall led to the broken key. And as I indicated earlier on, that version is the one which has been fully corroborated by all the justices who testified. In relation to the Cape Bar complaint, both witnesses have clearly corroborated each other, and those witnesses are Advocate Breitenbach, SC, as well as Mr. Parker, the brother of the respondent. And clearly there was a deficit in the trust account, and there's clear evidence of misappropriation of the funds in the trust account. And lastly, the respondent was fully aware of it and went to the extent of making arrangements to see to it that the discrepancy, the deficit is reduced and eliminated. So the evidence has gone to the extent of proving that fact of him knowing. And all of that took place prior to him applying to act, as well as receiving the permanent appointment as a judge. The issue then that has to be decided by this tribunal is set out in paragraph 14 of my heads. And the issue is individually and cumulatively, has it been established through the evidence that the respondent committed gross misconduct in relation to both those complaints? From paragraph 16 up till paragraph 44, I then deal with the evidence sequentially, and I request that I do not reiterate what is set out there. The Judicial Services Council derives its authority from Section 177(1) of the Constitution to respond to complaints, and thereafter it tasks the committee and as well as this tribunal. And Section 177 correctly is about the removal of a judge. And it is on those bases that in paragraph 44, I put that section as the basis of the legal framework. I make reference in the heads to 3 judgments: the Hlophe versus Judicial Services Commission and others case, the Freedom Under Law and Judicial Service Commission in another case, as well as the Makubela case. Those 3 cases guide us in this tribunal as to which approach we ought to follow. And it is also correct that the Freedom Under Law and Judicial Services Commission case took it in paragraph 94 of that judgment that as part of the recommendation by this tribunal will be that the JSC must invoke Section 177(1)(a) of the Constitution. Towards the end, I make the point, Chair, that throughout this saga, the respondent had the opportunity to apologize for what had happened, particularly in relation to the tension which took place in the Western Cape Division, the consequences of his conduct. We haven't had that, and it is with submission regrettable that nothing of that sort, an apology, has not been forthcoming at all from the respondent. In conclusion, Chair, my submission is that the respondent in this matter rendered himself guilty of gross misconduct as set out in the evidence. He did not dispute or refute any allegations which have been placed before this tribunal, and accordingly, I urge the tribunal to recommend to the JSC that the provisions of Section 177(1)(a) of the Constitution be invoked. Those are my submissions, Chair.
Yes. I think Mr. King says we can recommend.
I rely, Chair, on paragraph 94 of the Freedom judgment for making that submission.
Okay. All right.
I do not align myself, Chair, with the minority of that judgment.
Okay. All right. Yeah. I don't have any questions to you.
I have no questions.
Okay, thanks. Yeah. Advocate McKay, or is it Mr. Butlender?
Good morning, Chair and members of the Tribunal. Ms. McCurdy has suggested that I go first, which I'll be happy to do, if that's convenient to the Tribunal. Chair, I'm like our colleague, the evidence leader, I'm not going to traverse the evidence in detail. It's all undisputed. I'm going to deal briefly with the following matters. Firstly, I'm going to deal with the 2 conflicting versions. Then I'm going to make submissions as to the task of the tribunal. Thirdly, I'm going to make submissions as to whether this conduct constituted gross misconduct. And fourth, I will address what we call submit as the aggravating factor. And finally, I will make submissions in conclusion. Chair, as to the two conflicting versions, as we all know, Judge Parker has given two conflicting versions as to whether assaulted by Judge Lope. We submit that the outcome of this inquiry is the same, whichever of those two versions is the truth. We do say, however, that the overwhelming probability on the evidence is that Judge Lope assaulted Judge Parker. That is what he said in a contemporaneous affidavit which he dictated, and it's what he said in his discussions with 8 of his judicial colleagues over a period of about a year. We submit that the truth is most likely what Judge Parker said contemporaneously in his affidavit, contemporaneously to Judge Villa. That was in February 2019. In February or March 2019 to Judge Lachransi. Late in the third term of 2019 to Judge Henny. In October 2019 to Judge Sher. Late in 2019 to Judge Savage. In December 2019 to Judge Clutty. And in late January or early February 2020 to Judge Steyn. All of those accounts are consistent with each other and with the affidavit that he made. If that is the truth, then the unavoidable conclusion is that Judge Parker lied in the letter that he wrote to Judge Lachransi. And I use the word lied. Lied is an ugly word, but there is no justification, I submit, for using a euphemism which makes what he did seem less serious. Deliberately told an untruth. He did so in his letter to Judge Lachransi, and he also did so when in February 2020, he confirmed to Judge Lope that Judge Lope's draft affidavit to the JSC stating that no assault had taken place was the truth. The overwhelming probability we submit is that Judge Parker lied in order to confirm a false denial which Judge Lope intended to submit to the JSC under oath. We submit that if this is the case, it's extremely serious. The JSC needs to be able to rely on the truthfulness of what it is told. A false denial, as in this instance, would amount to an attempt to prevent the JSC carrying out its constitutional function of establishing the truth with regard to an allegation of misconduct against a judge. That is, if the truth is that the assault took place. It gets no better if the truth is that Judge Parker was not assaulted by Judge Lope, because in that event, Judge Parker lied in an affidavit which he dictated, and he lied to 8 of his judicial colleagues over an extended period in continuous conversations over a year. This would mean that he repeatedly and over a year lied to his judicial colleagues and spread a false and scandalous allegation that the judge president had assaulted him, and he made that false allegation under oath in an affidavit. To turn then to the task of this tribunal, the tribunal is required by the Constitution and by the JSC Act to make a determination of whether Judge Parker rendered himself guilty of gross misconduct. The full court of the Gauteng High Court held in the Lope case that gross misconduct is conduct that renders a judge unfit for judicial office. And we submit that that is, with respect, a pithy summary of what the issue is. Is Judge Parker fit or unfit for judicial office? That is the test to be applied having regard to Section 177 of the Constitution. In our heads of argument at page 39, we set out what the Code of Judicial Conduct requires. In paragraph 56, we point out that Article 4A of the Code provides that a judge must uphold the independence and integrity of the judiciary and the authority of the courts. In Article 5.1, it provides that a judge must always, and not only in the discharge of official duties, act honorably and in a manner befitting judicial office. And in Article 5, sub 2, it provides that all activities of a judge must be compatible with the status of judicial office. Now, there may be some room for argument, Chair, on whether this is to be interpreted literally. For example, in a private discussion with a friend or a family member. It's not necessary, we submit, to decide that question in this case, because the lies in this matter were not in the course of private conversations. They were and divorced from the functioning of the courts. They were, in this matter, there are two possibilities. Firstly, that Judge Parker lied in a letter to Judge Lafranci, written on his judicial letterhead, and he lied in a discussion with Judge Hlophe to support a false denial of Judge Hlophe's, in Judge Hlophe's intended affidavit to the JSC. And it was about an incident which took place between two judges in judges' chambers. This is no private matter. We say even if private lies are not governed by the code, this was no private lie. The lie was in an affidavit and in repeated discussions. The alternative is that he lied, I beg your pardon, in an affidavit and in repeated discussions with 8 of his judicial colleagues about an incident which took place between him and the judge president in chambers. So this was no private lie. This was a lie which was right at the heart of what goes on inside the judiciary. So that brings me to, so we submit that a lie under these circumstances plainly constitutes misconduct in breach of the code. The question then is the third issue I want to address is whether this is gross misconduct. We submit that on either basis, whichever version is true, what Judge Hlophe did, what Judge Parker did was misconduct, and it was misconduct of a gross nature. And we address this in our heads of argument from paragraph 57 on page 40. In paragraph 57, we refer to the notes to Article 5, which deal with a judge's duty to act honorably, which is at the very heart of a judge's function. We explain the notes to Article 5 explain firstly that a judge behaves in his or her professional and private life in a manner that enhances public trust in or respect for the judiciary and the judicial system. A judge avoids impropriety and the appearance of impropriety in all of the judge's activities. A judge does not engage in conduct that is prejudicial to the effective and expeditious administration of the business of the court, and judicial conduct is to be assessed objectively through the eyes of a reasonable person. We submit that a reasonable person, any reasonable person, would say what was done wrong was very serious and was gross. In paragraph 58, we draw attention to what is said in the bank law principles, which also govern the articles of the code. And they state that integrity is essential to the proper discharge of the judicial office, and propriety and the appearance of propriety are essential to the performance of all of the activities of a judge. In paragraph 59, we point out that in the application of the principles of integrity, the bank law principles shall ensure, the bank law principles state that a judge shall ensure that his or her conduct is above reproach in the views of a reasonable observer. And paragraph 59.2, most importantly, The behavior and conduct of a judge must reaffirm the people's faith in the integrity of the judiciary. If members of the public believe that judges who sit and adjudicate on their cases may be dishonest, that cuts right to the heart of the credibility of the judiciary and to people's faith in the integrity of the judiciary. In paragraph 67, we amplify this. Paragraph 67 at page 42, we point out that public confidence in the judiciary depends on the credibility of the conduct, honesty, integrity, and character of judicial officers. Public confidence in the judiciary is undermined by a demonstrated lack of integrity on the part of a judicial officer. In paragraph 59 to paragraph 68, honesty, integrity, and integrity are the hallmarks of judicial probity, and thus dishonesty is the stark antithesis of judicial probity. That is the issue with which this tribunal is dealing in this matter. And we quote what was said by the Supreme Court of Canada as to the standard of behavior to be expected from a judge. The public will therefore demand virtually irreproachable from anyone performing a judicial function. It will at least demand that they give the appearance of that kind of conduct. They must give the appearance of being an example of impartiality, independence, and integrity. What is demanded of them is something far above what is demanded of their fellow citizens. The test for gross misconduct was explained by the full court in the Gauteng case, and we set that out in paragraph 50 of our heads of argument. I've already referred to the question of fitness for office. In paragraph 50 at page 38, we say the following. The paragraph 50, the term gross misconduct we submit must be understood in the context of the whole of section 177(1)(a). This is what the full court found in the Hlophe case. When the other grounds of removal are taken into account, it's apparent that what is contemplated by the term gross misconduct is conduct that renders a judge unfit for a judicial role. In paragraph 51, we say what is required in determining whether a case has been made out for gross misconduct. This is again relying on the authority of the full court in the Hlophe case. What is required is a fact-specific inquiry into all the relevant events, upon which foundation a finding of fact can be made. I've already addressed the tribunal on those facts, which is then subjected to a qualitative assessment as to whether the judge who behaved in the proven matter is fit for purpose in a judicial role. This requires a value judgment to be made. And we submit that a judge who repeatedly lies on a matter of this kind, including in all probability, conniving in the submission of a lie to the Judicial Service Commission, is not fit for a judicial role. Whether I'm correct in that submission is a value judgment which the tribunal will have to make. But we submit that it is, one doesn't want to overstate the case, but this is one of the most serious sorts of misconduct that one will encounter. It is fortunately a very rare form of misconduct, but a judge lying on a matter of this nature and repeatedly lying on it is gross misconduct. We then, from paragraph 70, as page 43 of our heads of argument, deal with what I submit is the aggravating factor in this matter. The aggravating, paragraph 70, page 43, the aggravating matter aspect of his conduct is that despite the serious charges against him, Judge Pratka has refused to answer them at all. He refuses to make a statement setting out his response to the serious allegations against him. He refuses to give the tribunal any explanation of his conduct. There's a body of evidence against him which calls for an answer. He refuses to answer it. He failed to challenge any part of the evidence against it, but still refused to make any admissions in this regard. And to add, the matter referred to by the evidence leader, and he has refused to make any apology, give any explanation for any of this. And we submitted paragraph 71 that this conduct is itself unacceptable, bearing in mind the nature of the constitutional function which the tribunal and the JSC perform. We say that an appropriate analogy arises from the obligations of a lawyer who's facing an inquiry into their professional conduct. And we quote in paragraph 74 what the Supreme Court of Appeal said in the Hewitson matter, which was a striking off matter. The court said, by reason of the sui generis nature of the proceedings, this would require a full and frank disclosure of all material information so as to allow the court to make a proper and informed position. There is no room for an attorney who wishes to remain on the roll to be coy about material facts in a matter of this nature. As officers of the court, attorneys are at all times expected to be scrupulously honest and observe the utmost good faith in their dealings with the court, even if it means disclosing information which may be adverse to their own interests. And we submit in paragraph 75 that the same must apply with even greater force to a judge who wishes to remain a judge and wishes to continue receiving the lifelong benefits which flow from holding that office. A judge who wishes to remain such may not be coy about material facts in a matter of this nature and stay silent and say nothing. Judge Parker apparently wants to continue to be a judge and to be paid as such for the rest of his life, but he refuses to answer or account for his conduct in any way whatsoever. We submitted paragraph 76 that Judge Parker's conduct fell far short of the obligation resting on him and demonstrated a regrettable refusal to accept his accountability for his conduct. He has refused to account for it in any manner whatsoever. So finally, we reached our conclusion at paragraph 77, mission, armed the trust of the public and the courts. He has demonstrated a lack of the integrity which is expected and required. At paragraph 80, we say, to repeat, gross misconduct is conduct that renders a judge unfit for a judicial role. And we submit that a judge who acts dishonestly in this manner and then refuses to account for it in any manner, in any way, is not fit for judicial office. The public would be scandalized if a person of that nature, of that kind, would continue to sit as a judge and to draw a judge's salary. Paragraph 81, we submit that Judge Parker's conduct amounts to gross misconduct as contemplated by section 177(1)(a) of the Constitution. And for all of these reasons, we respectfully submit that the tribunal exercising its power and its function and its duties should make a determination in terms of section 26(1)(a)(4) of the JSC Act that Judge Parker rendered himself guilty of gross misconduct as envisaged in section 177(1)(a) of the Constitution. Chairperson and members of the tribunal, those are our submissions. Thank you.
And of course, apart from anything else, there's real evidence. There is objective and real evidence in the form of a broken key, a picture of which we were given, which at the very least suggests that there must have been an altercation of some kind. That's real evidence.
Yes, indeed. Yes, indeed, Chair. And it's unexplained.
Yes. Advocate, sorry.
The point was made by Advocate King, I think, in his heads, that it's not for the tribunal to make recommendations as to sanction that should be imposed on Judge Parker. Do you have any submission in regard to that, the correctness of that submission?
Judge Berkowitz, with respect, we agree with that. What the tribunal is required by the Act to do is to make findings of fact, and if the conclusions, it has to make findings of fact as to what happened, and as to whether the judge committed conduct, committed gross misconduct. It's then for the JSC itself and of course, Parliament following in the JSC to determine what the sanction should be.
Thank you. That's all.
Except that, Mr. Butland, except that we're entitled to express ourselves on the merits of the case. I suppose at the end of the day, it may come down to a matter of the language used by the tribunal, because surely the tribunal will be entitled to say that the nature of the misconduct is so gross that it warrants the triggering of the Section 177 mechanism. That's part of the merits. The merits of the case relate also to the gravity of the matter. But anyway, I suppose it's a matter of formulation.
Chair, yes, with respect, it is a matter of formulation. I submit that what the tribunal ought to find is that Judge Parker committed gross misconduct in that his conduct renders him unfit for judicial office. And the JSC will understand what that means.
Yeah. Thank you. Advocate McCady.
Thank you, Chair.
Thank you, Chair. I won't repeat what has already been submitted in respect of this matter and certain of the law. Just to start, though, in regard to the Cape Bar complaint, when the Cape Bar was informed of the finding of the JSC in October 2020, in accordance with Section 19(1)A of the Act, it was stated that Judge Parker and his partners may have misappropriated funds of the true creditors while he practiced as attorney and acted in breach of the rules of the Law Society over a long period of time by not disclosing to the Law Society when there was a trust deficit in the trust account of his law firm. His failure to disclose in his nomination questionnaire and in interviews before the Commission that the trust account of his law firm had had a deficit for a long time while he was managing director is extremely serious and would constitute gross misconduct on his part. Going from there to the hearing before the tribunal on the 25th of February 2025, as with the other complaint, there were no admissions on the part of Judge Parker in regard to any of the conduct. In fact, he stayed silent in respect of both matters. Importantly, and in respect of the Bangalore Principles of Judicial Conduct, and which informs the Judicial Code, and Value 3 refers to and provides that integrity is essential to the proper discharge of the judicial office. And in that regard, a judge shall ensure that his or her conduct is above reproach in the view of a reasonable observer, and the behavior and conduct of a judge must reaffirm the people's faith and in the integrity of the judiciary. The commentary on value 3 is instructive, and this is at paragraph 24 of the heads of argument, where it says that a judicial officer must be free from fraud, deceit, and falsehood, and be good and virtuous in behavior and in character, and that integrity is absolute. Of course, and as Breitenbach SC indicated in his affidavit, which was in support of the complaint, there are 2 points that emerge from the affidavits filed by Judge Parker's brother, I.K. Parker, in the LPC proceedings. And of course, in those proceedings, there were 3 affidavits filed by Judge Parker's brother and no affidavits filed by Judge Parker. What is apparent from the affidavit of his brother, and his brother confirmed the content of these affidavits at the hearing, was that Judge Parker was aware of the trust account deficit before he started acting as a judge in October 2016, and that his awareness continued during the period of his acting appointments. And while his application for a permanent appointment was underway, and after that permanent appointment, Judge Parker has not disputed this. Secondly, that the deficit in the firm's trust account and Judge Parker's knowledge of the maladministration of funds were matters that he should have disclosed to the JSC as matters which would cause him embarrassment as a judge. It was further relevant matter and with full knowledge of the misappropriation of funds that Judge Parker misled the JSC on his questionnaire, failing to disclose circumstances which would adversely affect his suitability for the bench. Again, this is not disputed by Judge Parker. And in the absence of any other version, and there is no other version, Judge Parker's misconduct involves dishonesty. It is as simple as that. Of particular concern, and this is dealt with at paragraph 27 of the heads, is his message to his brother to take 35,000 Rand from their mother's trust monies for him as a loan to pay him when he was an acting judge, as his salary would only be paid mid-month. This was on the 2nd of May 2017, a month before he completed his application. This conduct, which is uncontroverted, demonstrates not only knowledge of misappropriation of funds and a failure to disclose that, but that he actively participated in the misappropriation of funds. What does appear from the affidavits in the matter before the court, where the LPC is the applicant, is that there was and has been an attempt to pay back certain of those funds, and in fact, the full amount was paid back in due course. Whilst one may consider this to be conduct showing some remorse or an attempt to right a wrong, it is apparent from the WhatsApp conversations and as set out in the affidavit of Breitenbach that the motivation for paying this back was somewhat more selfish. It was done in order for I.K. Parker and Khan, the other partner, to obtain a Fidelity Fund certificate for 2020. And second, it was by the LPC against them. It was also, of course, to try and avoid any charges of theft being laid against them. We say that the conduct of Judge Parker constitutes gross misconduct. It demonstrates a clear lack of integrity and elicits reproach from a reasonable observer. Moreover, it undermines the public's faith in the integrity of the judiciary. Advocate Budlander has addressed the question of what constitutes gross misconduct, and we say that, and align ourselves with the submissions made, that it is conduct which renders a judge unfit for a judicial role. And indeed, in this matter, not only the gravity of the conduct which was discovered in regard to the misappropriation of funds in the firm's trust account, but the failure to disclose these trust account deficits in his application, while knowing of this from prior to being appointed as a acting judge through to him being appointed as a permanent judge, warrants a finding that he should be removed, or that he should not sit as a judicial officer because it is of such gravity. Of course, and this is referred to in paragraph 33 of the heads, we refer to the Milan judgment, which indicates, and where the comparison is made, whereas an attorney, if you would be struck from the role of attorneys, and it was found that you could not act as an attorney due to your gross misconduct because of misappropriation of trust funds, then similarly, as a judge with knowledge of and participation in the misappropriation of trust funds in your former firm, that too should trigger the removal from office in the case of a judicial officer who acts dishonestly. The facts that are before the tribunal in this matter are undisputed. They demonstrate severe and serious misconduct on the part of Judge Parker, and we say that this is gross misconduct where dishonesty, lies, misinformation, misleading have occurred throughout his application, throughout his term as an acting judge and as a permanent judge, and that the extent of this dishonesty does indeed undermine the people's faith in the integrity of the judiciary, should make a finding that the conduct of Judge Parker amounts to gross misconduct in terms of Section 177 1A of the Constitution. Thank you.
Thank you, Advocate McKedy. Mr. King.
Thank you, Chair, and thank you, members of the tribunal, for hearing me. The first issue I wish to raise is the issue of dispute of facts. Judge Parker elected not to dispute the facts. I would respectfully submit that that's not an aggravating factor, and it's
failure to dispute of facts is not an act in terms of the sanction or in terms of the gravity of the misconduct.
That would be the proper question. In terms of the sanction, we're not dealing with the gravity of the offences in this silence of Judge Parker in these proceedings.
So we can very much, in determining whether it's gross misconduct, take into account his silence. In fact, one must inevitably do that in order to establish the facts.
That could be that would be proper. What I'm talking about is aggravation as in imposing a sanction.
Well, it doesn't lie within our power to recommend a sanction.
I'm in agreement.
That being so, the issue of aggravation, except with regard to the seriousness of the misconduct, does not arise with us or for us.
That's correct.
Dr. Nsing.
Chair, I've got nothing further. I stand by my submissions.
Mr. Butland, any response?
Yes, Chair, just briefly on this last point, we submit that the refusal to deal with the allegations, the refusal to make any admissions with regard to the allegations, the persistent silence with regard to the allegations is an element of the gross misconduct. Appearing, striking off, who's appearing before the Law Society is obliged to disclose to the Law Society what happened. That is an element of the seriousness of the misconduct, and it then arises in a different context if the JSC and the National Assembly come to consider what the sanction should be.
Yes.
Thank you. Thank you.
Yes. Advocate McKedy.
Chair, just to say that I align myself with the submissions made by Advocate Budlander on that point, that the failure to participate in the process at all is a factor which the tribunal should take into account. There is no apology, there is no explanation, there is nothing before the tribunal from Judge Parker, and that should be taken into account. It's a serious aspect in regard to the hearing and his duty, we say, where he should have taken part in and provided an explanation. Thank you.
And for Mr. King's comfort, aggravation, even as we are not to deal with sanction. Do I make sense, Mr. King?
Sorry, Judge, I'm just trying. Yes.
Aggravating only with regard to the seriousness of the misconduct. But
Judge,
we're limited to that, but not aggravating as in relation to the sanction, which you say is not our territory.
That's correct.
Yes.
Something further has to happen in these hearings before a sanction is imposed, and that hasn't come about yet. The JSC has a hearing still to be held, and at that hearing, that all the facts may or may not be disclosed that we're talking about at this stage.
Mr. King, what do you make of Mr. Budlander's submission that the aggravating features of this, the silence in the face of all this evidence, is evidence of gross misconduct? It supports an inference of gross misconduct.
Judge, in answer to that, I would respectfully submit that the hearings are to determine factual issues as to whether or not the conduct did or didn't happen. Now, Judge Parker is elected to not dispute those facts. He's elected to remain in the proceedings, be part of the proceedings, but not to contest it. And the normal result of that is that the issues then remain unanswered. He was not called on to, in these proceedings, to put up a defense as to whether or not his silence should be used to prove that he's not competent to be a judge. That wasn't the grounds on which we came to this before this tribunal.
No, he wasn't asked simply to come or the tribunal wasn't just there simply to determine whether there was misconduct. We came here to determine whether there was gross misconduct. And in coming, in determining whether or not the conduct was gross, why would we not take into account certain ugly features relating to the manner in which he conducted his defense? I'm saying ugly features to avoid the word aggravating, because it seems the word aggravating seems to be dragged into sanction. Why are we not in determining whether, because we are to determine whether or not his conduct was not just conduct, but gross misconduct. Why? In determining whether or not his conduct was gross misconduct, should we not take into account certain factors that look ugly?
Judge, the issue that looks ugly, as I understand it, is the fact that Judge Parker has elected not to dispute the facts placed before the tribunal. Sorry.
Or that he didn't apologize. He did not offer an apology.
That is a fact.
Or an explanation for anything.
That is a fact that the court, that the tribunal must consider. That is part and parcel of what's taken place. But it's not a simple fact that it's now because he hasn't, in this tribunal, I'm not talking about outside of it, but in this tribunal, elected to stand up and say, I apologize and I want to explain what happened. That shouldn't, I would respectfully submit, be taken as something that is ugly.
Sorry, I didn't hear you. You say something should or shouldn't? I'm not sure. I heard you correctly.
Okay. The fact that in this tribunal, he has not apologized. My submission is that that should not be seen as being ugly. That can and will probably take place before the JSC, the decision maker as to the aggravation or mitigation function of that tribunal or that committee, and what they recommend should go forward to a parliament.
I hear you.
Mr. King,
Yes.
we accept that it's not our function to consider the appropriate sanction However, in determining the relevant facts, and particularly in this instance, we have to determine whether Judge Parker is guilty of gross misconduct. It's an accepted legal principle that if you fail to give evidence, the triers of fact have every right to draw the most adverse inference against you. Here we have a number of inferences to be drawn, the most important being whether he's telling the truth or not. And we are entitled to draw the most adverse, an extreme inference against him, and in determining what the factual position is. And I would say, to describe the adverse inference that's to be drawn as aggravating, perhaps is a question of degree, but we are certainly entitled to take into account his failure and his silence. That is the most critical element in determining the facts of misconduct in this case.
Judge, because he's silent, he hasn't spoken, the allegations against him would be accepted, that there can be no dispute of. However, this would seem to be an extra onerous bad issue that has cropped up, where the extreme inference is now going to be drawn that he's not going to say sorry. And I would respectfully submit that would be somewhat further down the line that should take place.
I'm not
Where
saying...
he opens up and gets the opportunity to do so in representations.
Look, I'm not suggesting that he won't have the opportunity to speak in mitigation of sentence, of sanction. I'm talking about drawing inferences, adverse inferences against him in these circumstances, in our factual determination of gross misconduct.
Judge, I'm not disputing that.
Thank you.
That is an issue that is simple law, and you are correct.
Thank you.
Thank you, Mr. King. And unless there's someone who strongly feels that they should say something, this would then conclude argument. And tribunal reserves its decision. We will communicate our decision in due course. Thank you very much, and thank you for your time.
Thank you, Chair.
Thank you, Judge.
Thank you, Chair.
Thank you. Proceedings are then adjourned.